All right, let's go on the record on DC 226174, Shanta Jones versus Valiant Enterprises LLC. Counsel, make your appearances.
Joshua Lee for the plaintiff, Shanta Jones.
And Christopher Lawless and Alex Caravio for defendant Valiant Enterprises Incorporated.
Have you guys submitted a notebook for me with, because there's quite a bit of briefing on this?
Yes, Your Honor. I think our legal secretary sent it to you yesterday.
Okay, let me go find out. Let me put you on hold 1 second. Okay, you may proceed. I've already read everything.
Thank you, Your Honor. I think I'll begin since it's defendant's motion we're here for, the hybrid no evidence and traditional motions for summary judgment. Defendant is moving on no evidence ground for each of plaintiff's claims: the negligent activity claim, the negligent undertaking claim, the premises liability claim, and the gross negligence claim. We are moving for traditional summary judgment on the negligent activity claim, the negligent undertaking claim, and the gross negligence claim, excluding the premises liability claim under traditional. Your Honor, since you've read the documents, is there any way you would prefer I approach this? Do you just want me to start from the top and go down?
No, I'll have some questions for you, but you can get started.
Okay. Well, we'll start first with no evidence, then I believe. Starting first with the negligent activity claim, Your Honor, it's defendant's contention here today that there is no evidence for breach of duty or causation. Plaintiffs responded to the no evidence summary judgment motion with argument that defendants have breached the standard of care and that the causation was caused by the failure to address a ceiling. However, in that same response, they admit that they're not bringing any claims from a negligent activity or contemporaneous negligent activity. So I'm a bit confused here on how they're asserting there's evidence of a negligent activity claim when they're not bringing any claims on a negligent activity. But to address their response to no evidence, the standard of care that they're asserting is that there should have been these inspections. There is no evidence that these inspections were contemporaneous to the accident in question that occurred on December 15th, 2021. That's just an argument under premises liability that they're trying to assert as a breach of duty under negligent activity. And as far as causation for failure to address the ceiling, the failure to address the ceiling is the breach of duty for premises liability, the correction of the condition of the premises, Your Honor. So neither argument addresses the no evidence for breach of duty or causation for a negligent activity claim. And so that's why defendants are
let me ask a question here. So is there any question that the plaintiff was an invitee at the time of this accident?
No, she was a resident of the apartment complex.
Okay, so you're not contesting that she's an invitee?
Correct, Your Honor.
Okay, go ahead.
So then to move along to the next claim, the negligent undertaking claim, again on no evidence grounds, defendants contend that there is no evidence of an undertaking or a promise, a breach of such promise, and there's no evidence of reliance by plaintiff on that promise or any alleged promise. In plaintiff's response to the no evidence summary judgment on the negligent undertaking claim, they assert that the undertaking that defendant did was performing these weekly inspections of the property. That's a bit of a circular argument because the premises liability standard that is brought is that these inspections were required. In fact, they retained an expert that says these inspections were required to meet the standard of care. So what plaintiff is in effect arguing here is that defendant is required to do these inspections per premises liability claim, but by doing these inspections, they're performing a negligent undertaking, and there's no case law to support that defendants are required to undertake this extra burden or extra claim simply by doing inspections that are required by the standard of care for premises liability. So I don't think that argument holds to show that there was any promise or activities done by defendant that caused an increased duty of care. The duty was already there for premises liability. Negligent undertaking is a separate claim. Also, as far as breach of duty, again, they're saying there was no contemporaneous activity. So these inspections that they're asserting were not contemporaneous. Any alleged breach of these inspections was not contemporaneous. And there's no evidence that plaintiff even knew these inspections were going on to show any kind of reliance on these inspections. So despite plaintiff's reliance on these inspections for a negligent undertaking, there's just no evidence there. That's simply, again, the premises liability claim.
Okay.
And then moving right along to the premises liability claim, defendant only asserts no evidence to the element of unreasonable risk here, Your Honor. Unreasonable risk has to be foreseeable and it has to be sufficiently probable to be an unreasonable risk. Defendant holds there's no evidence that it was sufficiently probable that this ceiling was going to collapse.
What wasn't there complaints made about this ceiling prior to the incident, or at least there's a fact issue on that?
Plaintiff alleges that she complained about the ceiling hanging the day before the accident on December 14th when the accident occurred on December 15th, Your
Honor.
Okay. But as far as sufficiently probable and foreseeability, the complaints of this ceiling were that it was hanging, what I understand from the expert testimony, a few inches from the side of the wall, I guess. Otherwise, there were multiple nails in the ceiling, multiple nails attaching it to its foundation. There was no indication, there's no evidence of testimony that this ceiling was in any way about to fall, other than this large wind came in and just happened to catch it. I think the sufficient probability standard, there was no sufficient probability the ceiling was going to fall. No evidence of that, absent this wind event or this unforeseeable cause of nature. Plaintiff responds that with the testimony of Kevin Gregg, a groundskeeper or pool guy essentially for defendant, and Gregg's testimony that he had seen prior hanging ceilings in the past. Most recently, to his knowledge, 6 months prior to the date of the accident, and then as far back as several years. The problem with plaintiff's reliance on Mr. Gregg's testimony is, one, Mr. Gregg might have seen hanging ceilings, but they didn't cite any testimony where he saw these ceilings fall. So just because he saw hanging ceilings does not create any sufficient probability that they would fall. There's no testimony cited by plaintiff that Gregg knew that. Furthermore, they're trying to, I guess, impose Gregg's knowledge of these prior hanging ceilings that occurred before defendant ever took management over the property. I can't stress enough that defendant only managed his property for 6 weeks prior to the accident. And during that 6 weeks, there's no indication that defendant Valiant had ever seen a hanging ceiling, no evidence of record that any ceiling had ever collapsed or fallen or been blown by the wind during those 6 weeks. And any imposition of a low-level employee's knowledge from his time before his employment with defendant is extremely overburdensome on businesses. There's no case law cited that kind of standard is placed on businesses for them to have all the knowledge of every employee, including low-level employees. So just because Mr. Gregg knew of some hanging ceilings long before Valiant took over the property, that's not sufficient to show that some risk is foreseeable or sufficiently probable, Your Honor.
Wouldn't he have an obligation to report that to his superiors?
I don't think Mr. Gregg would have an obligation to report that there was a hanging ceiling 6 months to several years prior to Valiant taking over the property. No, Your Honor. If he saw it while Valiant was managing the property, I think if he saw a condition of the property right then and there, yes, he would have an obligation to report that. But that's not what we're talking about here, Your Honor. We're talking about trying to impose his knowledge from several months to years back onto a new employer that hired him a few weeks before the accident in question.
Okay, do you have anything else?
Just moving along to the no evidence on the gross negligence claim, Your Honor. Defense argues there's no evidence of an act or omission which involved an extreme degree of risk, which to some extent we just spoke of. And we argue there's no evidence of a conscious disregard of plaintiff's safety by defendant Valiant. With regards to the act or omission of the extreme degree of risk, Your Honor, I just argued that it's not even an unreasonable risk for the premises liability standard. All that applies even more so to whether or not it's an extreme degree of risk under a clear and conscious standard for gross negligence. That just plaintiff makes the same argument that Greg's prior knowledge should have been imposed onto defendants, but Greg was a low-level employee. For gross negligence, it has to be a vice principal's actions, not a low-level employee. So if you look at the 1997 Texas Supreme Court case, Hammerly Oaks v. Edwards, or as recently as 2005 with Quest International Commissions versus AT&T, Texas law has consistently made it very clear it's got to be a vice principal's actions for gross negligence, not some knowledge of the landscaper / pool boy. So Greg's knowledge does not show any kind of conscious disregard or extreme risk or anything of that nature, Your Honor. And so as far as no evidence summary judgment motion goes, that's defendant's position on no evidence. Do you want me to continue into traditional, or would you like to have plaintiff respond on no evidence?
Are you here to get married, ma'am?
My friend is, yeah.
Okay, great. Miss Banfield?
Yeah.
Okay. All right. Go ahead. Let me hear a response.
Sure, Judge. Excuse me. I'm getting over a little bug, so I apologize if my voice gives out a little bit. So first thing I'd like to talk about, Judge, is I do think that ultimately after the trial of this case, that this case is going to be submitted on a premises instruction, not a negligence instruction. I agree that it would be error to submit both questions, and based on the nature of the claims in this case, it's more than likely that the premises instruction with the Corbin elements is the right instruction to submit. That being said, the Texas Supreme Court and the Dallas Courts of Appeals have made perfectly clear that the plaintiff can assert both premises liability claims and undertaking claims and gross negligence claims together. The only mutually exclusive claims are the premises and contemporaneous negligent activity claims. Those two cannot be asserted together, whereas the others can. So that being said, first on the negligent undertaking claim, I think that the circularity that Mr. Lawless is pointing out is simply a misunderstanding of the nature of the claims. The undertaking claim has to do when a person, in this case, this property management company, takes on a duty that they did not need to do, right? And so they chose to go about doing these weekly and monthly inspections. And it is clear from the contract that is between these parties. It is clear from the infrastructure of the apartment itself that Miss Jones necessarily had to rely on the property management company's reasonable conduct in this regard. For one, there's only one way in and out of her apartment. It is that stairway where she was struck by the falling ceiling, which means that she relied each and every day when she entered in and out of her unit that they did their job to inspect the property and make sure that they caught any unreasonably dangerous defects. Secondly, the contract itself states that she is not allowed to do repairs herself to those common areas, and so she had to rely on the property management company to identify those issues and repair them. So that I think is the basis, the factual basis and the legal basis for the undertaking theory. Whereas on the premises theory, the issue is not whether they have a duty to do a reasonable inspection, although that certainly can inform the question of whether they acted reasonably in causing the injuries or not. But really, the duty, as the court certainly knows, is that the property management company must warn or make safe an unreasonably dangerous condition. Now, an inspection might be needed, an adequate inspection might be needed in order to as part of that discharge of duty, but it's not necessarily exactly the same thing. And so there is no circularity problem, as Mr. Lawless is attempting to argue.
I guess what case law do you have that would support your position that a negligent undertaking would be appropriate in this fact pattern, where there's an inspection requirement?
So let me see if I can, I couldn't find a specific case dealing with a negligent undertaking that took the form of an inspection, Judge. We did cite a few cases in our brief: the Stirrup case and the Torrington case is obviously the seminal case on that from the Supreme Court, as well as there's, I believe it was the Crooks case, if I'm remembering right, but let me just check. Yeah, the Crooks versus Moses case. But those didn't necessarily have to do with a property manager doing an inspection or undertaking an inspection, but stands for the proposition that this is a cause of action, that if you have facts that fit these elements, it's appropriate to submit an instruction on these bases. And I think that because it is an independent and separate theory, the same evidence can support two different claims. There's nothing wrong with that, Judge, especially in a situation like this where you've got multiple different things going on at different times with different individuals, like repairmen and this groundskeeper or the manager, all doing different things. I think it's just a straight application of the elements that we can find in those cases.
And then there was an argument made that I thought was interesting that said that in order to assert a premises liability case for gross negligence, I guess, or a gross negligence claim, that you would have to have the vice principal would have to have knowledge of the dangerous condition. I've never heard that. So is that, let me just ask my question just a second. Just a second.
I'm sorry, sir. I'm sorry, Judge.
I'm trying to ask the question. So what case law do you have to support that or refute that?
It's a new argument that I haven't had the opportunity to brief, but I am a little bit familiar with this, Judge, because I have looked at gross negligence many times. It's partially correct. It's partially correct that a vice principal's knowledge is needed to support an element of gross negligence. It can be a vice principal. It can also be, under the statute, a manager with the ability to hire and fire. It can be somebody who's a department head or a manager of a sub department. It can also happen, it can also support gross negligence where the company or a vice principal or a manager ratifies the conduct or approves the conduct ahead of time. And so I think we do have some fact issues on that, where the property manager herself is approving of the way in which the folks like the groundskeeper perform their quote unquote inspections on a weekly and monthly basis. And so it wasn't raised in the briefing, but it is something that I believe there's evidence for, and I'm happy to submit supplemental briefing and evidence on that issue, because there are other bases other than just the vice principal's knowledge.
Was that raised in the briefing?
Your Honor, I did discuss in the reply that Mr. Gregg is a low-level employee. He is not a vice principal of the company. And I do want to address Mr. Lee that just misstated a couple facts that I want to make clear. Mr. Gregg was not the one doing the inspections. The manager was doing the inspections. So that's two separate arguments between the knowledge of Mr. Gregg and these inspections being performed that I'm happy to go into if I need to.
Well, in that case, Judge, and if the manager herself is the one doing the inspections, then I think that works, because she would be the one with the knowledge of the conditions at the facility. And so then we do have a vice principal or manager's knowledge to support the gross negligence subjective element.
Your Honor, there's no evidence that she saw a hanging ceiling during her inspections. So there's no evidence of knowledge by the vice principal.
And again, Judge, as Mr. Law said, this was raised in reply, and we had a chance to brief or look, specifically submit evidence on this issue. And as you know, the movement is not supposed to be able to raise new arguments in a reply brief, but I am happy to submit a supplemental brief on that if the judge would like to do that. Nevertheless, I think that the more appropriate outcome is to go ahead and reserve judgment on the gross negligence case. And frankly, if there isn't enough evidence at the trial to submit to the jury, then so be it. Then we can, then you can go ahead and say, well, I didn't see enough evidence of gross to submit it. But if we do that now, then we're in a situation where we may not be able to get the relevant evidence into in front of the jury because and the defendant haven't done this yet, and they may never do this, but I can see a situation where they say, well, that's only relevant to the gross negligence claim, and obviously you've dismissed that already, Judge, so it's not appropriate for you to enter that evidence, for example. I've heard that argument before, so I think it'd be a better approach to reserve on that to the extent that the court is even inclined to consider it based on this new argument, and allow us to develop our evidence at the trial, and then you can make a determination based on a full view.
I tend to agree that if it wasn't raised in the initial briefing, that it's not appropriate, and you can make a new motion for summary judgment. But at this point, I'm not going to entertain that particular argument. So, did you have any other arguments about why gross negligence wasn't appropriate?
Your Honor, if you're addressing me.
Yes.
My argument, it still stands that Mr. Gregg's knowledge that he had prior to being hired by defendant Valiant, regardless of any vice principal knowledge or anything of that nature, it would be hugely against public policy, and no case law was cited by plaintiff that you impose the knowledge that every employee, regardless of their level of employment, has prior to being hired, that you can impose that as a gross negligence onto the company. Mr. Gregg's testimony that was cited is of hanging ceilings that did not occur while Valiant Enterprises managed the property, did not occur within a reasonable time frame before Valiant Enterprises managed the property. And there's no level that you can add that kind of knowledge to support a gross negligence claim against Valiant Enterprises.
And Judge, if I could briefly respond to that, I think that there's two problems with that argument. First of all, I think it is Hornbook agency law that corporations are imputed with the knowledge of their employees who are working in the course and scope of their employment, because obviously corporations don't have minds to think for themselves. They must necessarily get the knowledge from their employees, and it would be inappropriate in this case for that argument to carry the day for the defendants, because there's no basis for them to blame prior managers of the property for a number of reasons, the most significant of which is that they're not a party in the case. They're not, and they're not responsible third parties properly designated by the defendant. And we don't have in front of us in this record any disclaimer of liabilities that Valiant may rely on to say that these prior entities kept any liabilities associated with personal injury actions. I don't think they have that, for one, but also, it's not as part of the record. And so that's sort of an argument to say, well, it's not our problem, it was the guy we bought it from. That's not the way that this should work, especially when they haven't raised that issue in the form of trying to bring a cross claim or a responsible third party action or something of that nature. And in any event, to just go back to the fundamental point, the corporations, I can cite you any number of cases, Judge, if but it is axiomatic that the corporation is imputed with the knowledge of its employees. Not just Mr. Gregg, but also the individual who came to fix Miss Jones' dryer, who she pointed this defect out to the day before the accident. So it's not just Mr. Gregg, it's multiple employees.
All right. I'm going to go ahead and take this under advisement, and I will try to get you a ruling within the next 3 weeks. Okay.
Thank you, Your Honor. Do we need to go into traditional summary judgment?
I'm sorry?
Thank you. Do we need to go into the traditional summary judgment arguments?
No, I think I've read the briefing. I think I'm good.
Thank you, Your Honor.
Thank you, Judge. May we be excused?
You may. You have a great rest of your day.
You too. Thank you so much. Have a nice weekend.
Okay. Let everyone on Zoom. Okay. Are y'all? What are y'all here for?
Yeah, I didn't see it on your docket either, I
Yeah.
think this morning, but I haven't, we are here because of a notice of hearing that said that we were gonna be having a 10:35 hearing on a motion to compel in front of you. And I didn't, I checked the docket this morning to confirm that it was at 10:35, and then that's when I noticed that it wasn't on the docket.
That could be our mistake. I don't know. But I didn't see it on today's docket either. What?
Judge, they didn't file a response, and so I think that it sounds like there was a mix-up, and so I'm happy to reschedule it if, I mean, I thought it was odd that they didn't file a response, but I was just figuring maybe they didn't want to. But it sounds like there's a mix-up, so I'm happy to reschedule.
And that's not filing the response shouldn't make it not be on the court's docket.
No, I understand, just found it odd that they didn't, so it sounds like maybe there is a mix-up. Happy to reschedule someone.
Well, I mean, I'm, let me just ask this, when did you get the notice of hearing?
I think last month sometime, Your Honor. I certainly don't have any exception to proper notice of the hearing.
Because, I mean, it could be that the clerks didn't enter it onto the system. I don't know. I'm happy to reschedule it. I'm also happy if you guys both would rather, you're both here. Y'all are ready to argue it and you want to argue it today, I can hear it today.
I'm fine with that too, Your Honor. The hearing today, just so the court is aware, I have an 11 o'clock that is in front of Judge Deidre Atkins, especially sets at 11 o'clock.
Okay.
And so I don't know if, I had it earmarked for a 30-minute trial. 30-minute hearing, so I don't know if the issues that Mr. Neely wants to present to you will take more than 30 minutes, but
I don't know what this is about at all, so
Judge, I don't think it'll take 30 minutes, but Ms. Green is going to handle this here.
what is it about? I don't even know what it's about.
Motion to compel discovery,
Interrogatories, depositions, what,
request for production.
have you guys conferred on them?
Yes, Your
How many are we looking at?
Honor. About 8 requests, I believe.
Is everyone here ready for the wedding or?
Yes, Your Honor.
Okay. Have you guys conferred on every single request?
yes, the writing is, in essence, they produced a writing that indicated their.
Have you talked about every single request?
I
Go
don't-
back to the conference room, talk about every single request and come back in.
Yes, Judge.
Thank you.
All right, you want to bring your folks in to get married? All right. Good to
Any
see you.
special rules I need to tell everyone?
Nope.
Just come on in.
Let's come on in.
Oh,
Let's get these folks married.
All right.
Been a busy morning, guys. I told you we'd have a lot going on. And so if you want to be able to watch the video of that hearing again, it's on my YouTube.
I've access to YouTube stuff.
Okay, are you guys here to get married? Who else here to get married?
They're not here yet. They're just right outside. They're here.
Like, no one's here to get married or no?
Yeah,
No,
they're
yeah,
here.
they are, they're right here.
Okay, great. Come on in. Congratulations. All right, you guys busy today. All right, is everyone here for the wedding?
Yes.
All right, everybody come on up. Come on up. Oh, you have a photographer here, it looks like, right? Everyone, come on up. Everybody come on up. If you're here for the wedding, come on up. All right, I need the license first.
Yes.
There we go. All righty, are you Samantha?
Yes.
You go by Samantha?
Yes.
All right, Samantha, you can be right here. Are you Carson?
Yep.
You're gonna be facing her, so you're gonna be, why don't you guys move this way a little bit? Are you guys exchanging rings today?
Yes.
All right, who's your maid of honor?
But I'm like, get over here.
Who's gonna be holding you?
He had.
I can give it to somebody.
We will give him now.
Come on out, maid of honor, come on over here.
I want to. Okay.
All right, so you hold his rings, and then who's gonna be your best man?
Probably My dad.
Okay, so you hold her rings. And then, all right, everybody who's here for the groom side, you come over here. You need to scoot up a little bit right there. And then you guys, everybody for groom side, come over here. Everyone for bride side, you guys come over here. So is this your mom?
Yeah.
Your mom and dad over here?
Yes. My brother.
Brother, okay, so you guys stay next to each other, mom and dad. She keeps up doing it in front of you.
Sorry.
So you go over here.
Oh,
Get one on. All right, and. Okay, why don't you guys come up? I want to get a little bit closer. So you guys get a little closer. Are you dad, your mom? Are you sister, friends,
Brother,
wife, husband, and okay, all right, perfect. Is this gentleman here with you?
No.
Okay, is this everyone that we're expecting?
Yes.
Okay, you're changing rings. Okay, great. You guys ready to get started?
Yeah.
We gathered here today. Celebrating Parsons. Across the world, culture and time, there's content. It is performed as a celebration in front of family. We celebrate the joining of two. Samantha, repeat after me. I, Samantha. Take you, Carson. My partner. And my. Loving you faithfully. Regardless of the odds. Thank you. Carson, give you this as a symbol of my love and faith. With this ring, I gladly enjoy my life. As I place it on your finger, which I've already done. All right, Carson, repeat it. I, Carson. Be my wife, my partner. I will cherish our union and love you more than share. Than I could. Laugh with you. Loving you. Regardless of the outcome. Symbol of my love and faith. With this ring, I gladly live. As I place it on your. I commit my heart and soul. I ask you to wear this ring as a reminder of the vow. To you, Samantha, take Carson to leave your office. And do you, Carson, takes a minute to leave your office. By the power vested in me by the state of Texas, I now pronounce you husband and wife. You may kiss them.
Did you write this out?
Yeah, well, kind of.
That was, yeah. I'm gonna take those and bring those to Spain. Yeah. They give me copyright.
Yeah.
Witness for Carson? You gotta need her hand.
We went to Tennessee.
Yeah.
I know, that's why I'm me too.
This is side right here.
I know.
How did you guys meet?
Oh,
Right.
yeah.
It's two weddings I've done today where the bride and groom were planted. High school. Where did you guys go to high school?
The Woodlands.
Oh, Houston. Okay, wow.
Yeah, we dated senior year and then dated to college. We went to A&M.
Oh, my God.
Yeah, I didn't- Jess mentioned, I think you went as well.
You went to
So-
UT.
Oh.
I went to UT.
They went to.
I went to UT, my kids went to UT, and my daughter's in law school.
Oh, wow.
No,
You got them instead.
yeah. Are you thinking of going to law school?
Yes.
Okay, that's so great.
If you end up going to law school, let me give you, if you are interested in going to law school, you want some advice. I'm recording it also.
Thank you so much. This is my representation. Bachelorette party.
Okay.
I practice from blog.
Oh, you do, okay. Probably need that for some bachelor. This is your license. You have both of this is not required. You do have two witnesses here. We'll get a picture with the three of us and we'll have the whole family. So, all right.
To really get that to actually.
Give me a hold.
Do-
You wanna take it with us?
Well, why don't we do the pictures in the front? We should go through the middle.
Yeah.
If you want it with the license.
Yeah.
Yeah.
And on.
Here we go.
All right, ready? 1, 2, 3. 1, 2, 3.
And then we'll get both families up here. So, bride's family over, or you guys, yeah, bride's family, I guess, over here, rooms over there.
Yes, we're here.
Oh, wow.
So
far, something else.
Alright, well,
I'll stand here.
we need to break up the name. Oh, maybe you can.
I know. All right, everyone look this way. Are you ready? 1, 2, 3. Okay, if you want one without. Yeah, we'll do one without. Perfect. All right, 1, 2, 3. Awesome. So look at them. Yeah. So much, guys. Appreciate
I get to
it. It
refer
was
you to me.
beautiful.
Jess.
Jess, okay, great. Good to see you again. Good
Yeah.
to see you.
Thank you so much.
Congratulations, guys. I hope you enjoyed it.
That was awesome.
Well, so that you usually, so it's up to you. We can deliver it. There's a lockbox downstairs. We'll deliver it to the county clerk. My experience is that that can take weeks. So if you're in any type of rush, you might want to take it back. So if you want us to just drop it in the lockbox, okay. Just be aware it may take quite a while for you to actually keep it.
Yeah,
So,
that's fine.
okay, all right, we will, can you give this to Rhonda and tell her to go in the lockbox?
Yeah, so we're not updating
Congratulations,
any.
guys.
Thank you so much.
They didn't have any candies, you need mine.
Well, now you-
Congratulations.
It's like our benefit. Like, we're just there.
I compiled them myself. I took a lot of different vows. I do those, I've done over 1,000 weddings. I use those vows for my.
No, we're not.
I have a different set of vows for.
Yeah, that's my orange hair. Really great.
I don't know. It's like titanium, plated. Yeah.
They have it next, they have it now.
Thank you again.
Wait, actually, so that's sweet. Yes, all right.
Nice weddings, weren't they? Weren't those nice? You see all sorts of stuff here. Yeah, oh, good. I once did 60 weddings in one day. That was it was right before COVID hit too, which was probably not the smartest thing. So anyway. So
Yeah, 1:30.
I hope not, because I don't have it. I don't think so.
I didn't know if the foreclosures or
No, that's the last week of the month.
the last week.
Yeah, no, we don't have. So, hello,
No,
what are you here for?
11 o'clock here in Chester.
Okay, good.
Morning, Judge.
Morning. How are y'all doing? Are you guys, you're on Chester versus Edwards?
Yes, Ron.
Okay. And is anyone here on NRA name redacted?
Haven't seen anything.
Okay. That may be a Zoom, okay. So I have another couple group of attorneys that are here on a motion to compel. They're in the conference room back here. Once they're done, I'll need to take that, but if you want me to handle the motion for new trial right now, I can. Or if you guys need to wait on anybody, we can wait.
There's been no response filed, Your Honor, but I hate to.
But the other attorney's not
I
here.
am the other attorney.
Oh,
I'm Robert Kelso. Good to meet you. Judge, I got notice of the hearing on Tuesday and then got very sick. I've got a response here. I've asked my office to file electronically, but it's just legal points. So it's the same thing that I'll with or without.
Did you already e-file the response or?
You gave it to my secretary this morning,
Okay,
but I've got paper copies for it.
yeah, this is really pretty short notice on it. What do you want to do?
Yeah, we can go ahead, Your Honor. First of all, I appreciate the court fitting us in to get us under the timeline.
Yeah,
It was short notice. I don't have any objection to him. There's no evidence, so it's just the arguments.
I do have some evidence. I assume that you'd have your client here to testify.
Well, he's available by phone, but we've also got.
Yeah, and that's part of the argument. I'll give you what I've got and then
why don't you do this? Why don't you call your client? I don't know if he needs to testify or not, but if you want to have him sign on to the Zoom, the court Zoom,
Okay,
that's probably the best way to do this.
I get the Zoom information.
It's on our website, the court website, so there's a link to just go right on it.
Okay, great.
thought, Stacy had a 11 o'clock somewhere. He's not gonna make it.
I'm sure he'll tell me if he needs to leave, so. Oh, so let me talk to you two real quick. Why don't you guys come up here real quick? So we talked to you about a scheduling issue. A couple things. So today, we have a lunch if you want to come with one of my former interns. She does transactional law, a big firm. I can't remember which one. And then at 2, we have the swearing in for Judge Craig. I would encourage you to come to that if you can. Schedule something. And then next week, we have this weather situation. And we also have a family commitment. The family commitment is that I'm planning on driving my son to Charlottesville. And back. It's a little bit of the campus of weather. So there's a possibility that we may have some Zoom proceedings. We may have, I just don't know what's going to happen on Tuesday. Yes, probably nothing, but you need to get the hours. So anyway, so that's something to be aware of. So did you guys both want to come to the swearing in? You want to get extra hours in this week's in Chicago? Yeah. No, there's no court on today. So we do have a pretty. I will definitely need you. There's a few days I need you. Next Friday is the so I do need you to help with some logistic stuff on Friday. So you can plan on being here a little bit longer on Friday. And then I'm going to send you a sample memo. Let me give you the notebook. One of the things that, kind of be aware of when you're writing notes is that here's a notebook that you need to pull the briefing. You have access to Westlaw. You'll need to pull the cases. When you're analyzing this, remember that there's 4 claims. And so you want to analyze for each claim whether or not the summary judgment should be granted. I think it's very likely that some of the summary judgment should be granted, some shouldn't. Then remember when you're doing this that you're applying the summary judgment standard. This isn't who should win at trial or who you think is a better briefing. You're using your legal analysis to apply the summary judgment standard, whether or not summary judgment should be granted. And so that a lot of times people have a problem with that, and that's part of when I'm judging you. Can you use the summary judgment standard and apply it to this vaccine with this one? So I think this is probably a slightly more difficult than average, but not incredibly more difficult than average memo that I'm giving out. So also this argument about vice principal is not briefed. It has to be briefed in the original motion. It can't be brought up in the reply. So you might say something in the footnote, but I don't want you to make a recommendation. And then there may also be objections to some of the evidence that you don't need to worry. Assume that I've overruled all the objections. Do you have any questions? And I'm gonna send you the sample. Sounds good. And you have a YouTube video to watch too. if you want. I know. Yeah, they did not show. They got canceled, so you're gonna get that a little bit. She can do what, 190 words a minute or something? Are you gonna help her do her court reporting? What? Eyelashes, okay. Oh, it's like, that's brave. You you can do the court reporting. Yeah. It should be about 30 minutes.
It's. Oh, no, those are.
I know I mentioned this kind of, but just be aware that you're welcome to copy anytime, but if the jury is back there, do not get caught, do not go into the room with the jury ever. But if you're welcome to, and if they come out and they're not here, you want to get copy of it. No. Do we have that, Gary? I don't think so.
So
Ask your question.
I was just wondering if there's a sign outside the jury. You just walk in, so is there a sign outside that there is jury?
usually it's locked back there and, but we got it kind of rigged up where you can just push it open. We'll let you know if there is a jury back there and stuff. So that won't be a problem at all.
Yeah, you usually will know.
Yeah.
Some courts, I think, do that if they're in deliberations, but this is just at any time. You're not supposed to go back there.
I try to leave it open so that way y'all can get in and out of it, because you don't have a key. You know what, peppermint?
I think so.
I'm getting prepared.
That sounds good.
Here's some Kit Kat.
Aw, thank you.
All right, are they signing on?
I think he's on the Zoom waiting to be put in, Your Honor, but
He's not on here.
he's having technical difficulties. He's on his phone.
Okay. Let's go ahead and get started. I don't know that we'll even need him, but we'll get started. Tony, you ready? Let's go on the record on BC 234121 Chester v. Edwards. Council, make your appearances.
Your Honor, Vince Vella for the defendant on this one, just Mr. Red Edwards.
And Tim Woods also on behalf of Mr. Edwards. Mr. Bell is going to handle the arguments and the witness.
And Robert Kelso on behalf of Brian Chester. Your Honor, would you like me to bring you, I gave them a copy of this, would you like?
Yeah, go ahead.
VELA. Yes, ma'am. VELA.
Okay, let's proceed.
Yes, good morning, Your Honor. Your Honor, the defendant here has filed a motion for a new trial and set aside the sum of the default judgment. Accordingly, Your Honor, the motion as drafted with the verification includes that the defendant, Mr. Edwards, had actually been primarily living in Santa Fe, New Mexico during the pendency of the suit. I believe he's moved there sometime in 2022, Your Honor. That's where he established his primary residence. According to the subservice rule 106, Judge, I believe service was, as plaintiffs effectuated, was to an Allen address, Your Honor. The Allen address being the subservice. The order was granted on July 12, 2023 to an employee at Mr. Parcel over the age of 16, listed the address Edwards 101, North Greenville Avenue, number C321, Allen, Texas. And again, Judge, during this time, it's a defendant's argument that Mr. Edwards had not been living in or anywhere near Allen, Texas. He's actually been living in Santa Fe throughout this process. And he hasn't actually received, or he did not receive notice of the petition or the filings or the default judgment until afterwards, Judge, until after the judgment had been rendered, which I believe was November 1st, 2023. Additionally, Your Honor, the motion for new trial and set aside default judgment indicates that we believe, or Edwards is under the position that there are meritorious defenses here, including a release, offset. It's my understanding, Judge, that Mr. Edwards had discussions with the plaintiff during this process, or excuse me, prior to the petition being filed.
So the defendant, or sorry, the plaintiff seems to argue, respondent seems to argue that there's no evidence your client actually lives in New Mexico. And you don't include an address or any type of, even I don't even think you said what city he lives in. How do we, and they said they've run a search and there's no proof that he lives in New Mexico. Is that, what evidence do you have that?
Well, Your Honor, we can certainly, if we could get him on Zoom, would testify. He's actually in New Mexico, Santa Fe today. I believe he's there right now. He's been living there, as far as I know, Judge, since 2022. This motion is sworn with the verification attached to it. So I'd argue that that would suffice in that sense. But he has, his position and our defendant's position here is that he has been living there throughout this process. Santa Fe, New Mexico, Judge, I understand I don't have a ballot or an address to actually provide you, but should we get on Zoom, I have no doubt he'd be able to provide a specific address.
We're on Zoom. He's not there. I don't know. He was told to sign on.
Your Honor, I have a phone number for him if you could testify by phone.
I usually prefer not to do that. But yeah, let's go and get him on the phone.
Would you like me to give the court the number?
No, you can do it. You guys will just need to move up here.
You're on phone with, Judge Hoffman and counsel.
Sir, why haven't you signed on to Zoom?
Sorry?
Why haven't you signed on to Zoom? This is Judge Hoffman.
I was asked to sign on so that I could be part of the meeting.
Why haven't you signed on to Zoom?
Oh, I am. I was in the meeting room right now. It just says Randy Edwards in the meeting room.
Did you send to mine? Did you look up the courts under Judge Martin Hoffman in the 68 District Court? Did you sign into mine?
I did, but I didn't have the meeting ID. I just signed in.
You don't need a meeting ID.
Okay. Anyway, I've been. It says that I'm in the meeting room, so right now.
I'm not sure. Okay, well, I guess we'll just go forward this way. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do, yes.
All right. Please state your full name for the record.
James Randall Edwards.
Okay. I'll let the plaintiff's attorney go ahead and ask you some questions.
Mr. Edwards, you alleged in your motion for new trial that you moved to New Mexico sometime in 2022.
Actually, I've been living here full time since 2020, but split time for part of that time.
Have you lived at the same address this entire time?
No, I have not.
What addresses have you lived at while you've been in Santa Cruz since 2021?
I lived at I can't remember that street number on Calle Largo, and then I lived on 442 Nazario, and then 6 Sunflower Circle.
Were those homes that you lived in, apartments, or what type of this?
Yeah, one of them was a VRBO and then the other one was a townhome, and the other one, the last one is a house.
All of them you've leased or your own?
Oh no, just leased, yeah.
And what is your present address?
6 Sunflower Circle.
Zip code that goes with that?
87506.
How long have you been at that?
About 11 months.
In July 21st of 2023, you renewed your Texas driver's license, is that correct?
I didn't, I don't know, did I renew it? I don't think I renewed it, but.
Do you have a Texas driver's license?
I do, uh-huh.
Do you have it there with you?
Yes, I do.
Would you read for the record the date of issuance and the address that you list in that driver's license?
It is 7/20/23, and it is the Greenville Avenue address.
Greenville Avenue. And
that was my address, my permanent address, during my time in Dallas, and when I was going back and forth to Santa Fe, and because I was living here most of the time, but I was there, part of the year, and then I did, after I
I have not gotten a New Mexico driver's license yet.
And you still maintain that, post office box in Allen, Texas?
No, I do not. Yes, so I think I need to get a new driver's license.
When did you stop, that address in Allen?
I believe that I gave the documents to council, but my recollection was in August.
You're trying to say they don't have anything like that. What documents do you have that show?
I sent the email that I sent to cancel the box, and just a confirmation of that to the mailbox of the central people. I forwarded that to council.
So as of you said in August of 2023, you canceled that address?
Yes, I did.
How did you get notice of the default judgment?
I didn't get notice of it until I came to clean out my pick up my last mail out of that box.
When was that?
I apologize for not knowing that date off the top of my head. Again, that was why I sent that to council earlier, so I may be able to find it. Okay, if I look for that real quick.
Sure.
August the 28th. And the email says that it confirms the conversation of August the 21st at approximately 11:30 a.m. that you were instructed to close box 321 effective immediately.
And did you receive a copy of the petition before or after?
After that,
So you terminated the box and then received the copy of the petition after that?
right, when I came to clean it out, which was probably within that week.
Randy, you're gonna need to speak.
You gotta speak up.
I'm sorry, yeah, I said yes. It was after I terminated it and when I came to clean out my box.
And when was that?
When was that, sir?
That's when you cleaned out the box and received a copy of the petition?
Yes.
And when did you receive a copy of the default? You're saying that you terminated the box and therefore noticed that the court would have sent you that facility should have been returned to the stop.
That's right.
Mr. Edwards. Other than the North Greenville Avenue address, have you had locations at 5709 Riverside Lane?
So that was a house that I owned with my ex-wife and we divorced in 2020.
7640 West Greenway Boulevard. Parking 4K.
No, that's not an address.
7270 Van Tile Parkway.
And that was a house that we rented, my ex-wife and I rented. We lived on first.
2700 Oak Grove Drive, Plano.
That was a rental home that I
17 Manor Lane, Lucas, Texas.
Yeah, it was a house that I lived in from 2015 to 20.
Do you have any explanation for the reason that public record search of your addresses would include all of those places that I just listed? Nothing ever in New Mexico?
I don't like this. I get mail from Mexico every day.
You get that at the address you told us.
Yes.
With regard to the offenses that you say some type of accord of satisfaction, that you made an agreement for Mr. Chester to give up the notes of the guarantees in exchange for being transferred of interest. Is that right?
Yeah, but again, my recollection of this is that Brian was a partner in the deal. So they are largest in that entity, and several times during the years that we were operating, we several of the partners did convert their debt interest and release their guarantees, convert it to equity. Brian had agreed to do that a couple of times, and then when the entity went into bankruptcy, and Brian actually funded the bankruptcy himself. It's my understanding that the money that once we actually signed over largest asset of the entity to Brian, and my understanding was that was to lease the guarantees and the debt.
Do you have any written documentation?
Wait, guys, wait. Are you guys leading the hearing still, or what's the deal?
Yeah, we agreed to reschedule. I have a doctor's appointment that I need to get to, and Mr. Demont is in trial downstairs. And there's some other outstanding discovery requests.
All right, so you guys want to reschedule this?
We were able to resolve the engagement letter, but we weren't able to resolve the other issue. So I'll call, and y'all aren't in the hearing, and get some dates, and we'll work out time.
Okay, that's fine. No worries. Thank you. You guys have a great weekend.
Thank you, Judge.
Do you have any documents in your possession of your attorneys where Mr. Chester agreed to release?
We're not having a trial here, so let's get moving on this.
I think this is my last question.
Okay.
Any document that would support your claim of some type of accord of satisfaction, release of Mr. Chester's note, guarantee. Do you have any document that would support?
I think in the bankruptcy documents.
provide anything with that.
Okay, this is way beyond the scope of what we're doing here today, so let's, that's all, sir. Do you want to ask any questions?
Your Honor, just briefly, Judge, for defense. Mr. Edwards, again, just in those conversations you've had with Mr. Chester, is it your position that you believe that those amounts that would have been, the default judgments in lieu of would have been released or otherwise offset based off of these added interests?
Yes, I do.
And as far as your Santa Fe address there, again, can you repeat to the court, how long have you been living in Santa Fe and how would you, let's ask that, how long have you been living in Santa Fe, New Mexico?
Since 2020.
And,
Full time since 2020.
and how long have you remained at that 6 Circle Drive address?
Yeah, I've been there since January of 2023.
Okay. And so where were you living before January 2023?
And on the Nazario address.
Is that also located in Santa Fe, New Mexico?
Yes, it is.
No further questions.
All right. Any response to the motion for new trial?
Witness be excused, one.
No, he needs to stay on.
Your Honor, I think we've stepped forward. I'm sorry. We'll have it.
Yes, Judge. Yeah, to Mr. Wood's point, I believe we set forward the requirements necessary for a motion for new trial. But effectively, Judge, our client wasn't living here in the state of Texas during this timeline. He's argued, testified today that he was not provided service of it until well after the fact. And I believe, Judge, more importantly, he does have meritorious defenses that can show that this, to prove or show that there are defenses involved with this lawsuit that we can allege in court. Additionally, I don't believe there'd be any undue harm or burden on the plaintiff in this matter. I would argue, Judge, that we can definitely get this back on track, get a new trial set, and keep everyone in the same position that they otherwise would have been.
Response?
Your Honor, is Al. Response. One, there has been no more evidence, specific facts, failure of that to be a good service. Edwards renewed his driver's license at that address less than a month before the service. Told you. I went through the addresses that were listed and none of them were in Mexico. What they have said in their motion is they're ready to go as soon as the plaintiff's paying new service on it. I think that's the reason we left out addresses. I don't think that new service is necessary. If the court thinks that it should grant this motion of request, granting the service.
We're fine. I agree. We made an appearance to conserve. We're in the lawsuit. No service is necessary. As far as restitution of law, legal fees, we'll reimburse him for the attorney's fees incurred in a fall judgment against Mr. Edwards.
How much is that?
I didn't.
How much is that?
It was 2,000.
That's his option. Agree with that.
All right. So go ahead and get me a new order. I'll go ahead and grant that. I think that's the right call. Go ahead and grant the new trial. It's on the record that the defendant has made an appearance in this case and no service is required. You can include that in the order as well. Also include that the granting of this motion for new trial is contingent upon the payment of $2,000 within 2 weeks of the signing of the order. Make sure at the beginning of the order it says that this hearing was heard on January 12th, 2024, instead of on this date. Share a copy of that. I want you to go ahead and agree to it as the form and get that to me by next Tuesday at 9 o'clock.
Your Honor, if I could, I think we're up against the 75 days. If I could submit that this afternoon.
When is the 75 days run?
It's still got. Judgment was granted November 1st. Motion from December 1st, so.
Or you can do this, take a copy of the order, interline it and bring it back to me right now. So why don't you go back there and you guys interline and bring it back. All right, guys.
Thank you.
Thank you, John.
The witness is released. You guys just bring me an order back in and the next meeting. Okay,
Thank you.
thank you, guys.